Thank you. And I have now the pleasure to introduce the final speaker of today, who is Dr. Andrea Jelinek. Dr. Andrea Jelinek is someone whom I don't really need to introduce here in all detail because everyone here in the room knows her. So I can be very brief. Dr. Jelinek is on the one hand the head of the Austrian Data Protection Authority. She has been serving in this position since January 2014. And on the other hand, she is also the chairperson of the European Data Protection Board. So she is on the one hand representing one data protection authority in Europe, and on the other hand, giving us an overall perspective of the European perspective. Mrs. Jelinek, I'm really pleased and honored that you are with us. You have the floor, please.
Thank you so much, Professor Forgo. I have the honor to speak the closing remarks for this conference. But before I do this, I want to react on the panel I heard before, and I want to react on the question of Professor Sjöberg, because she raised the question if the IT law experts should become more experts or go out, integration or concentration. And I really, and I'm quite free in speaking because I'm no academic, I really would appreciate if there is more integration, and if we see the integration, then there comes the concentration as well. I think the major track how to apply the law in the digital world is to speak with the technologists, to speak with the IT professionals, and to get the mindset of each other. I think it will be really important, and it is already important. I'm really convinced that we all have to leave our bubble, either the lawyers or the IT experts, because only together we can achieve what we really want. On the one hand, to be very open for new technologies, and on the other hand, to protect the fundamental rights of our citizens. And I think we can do this without leaving our core, because I heard we should keep our core. Yes, you're right. And I want to close to the reaction to the panel with the sentence that building bridges that Nadezhda Putova raised. And I loved her introduction regarding she was doing legal gymnastics when she was preparing for the panel, but not for the panel, for her introduction. She said building bridges is important. Yes, and building bridges was the motto of the International Data Protection Conference in Amsterdam 2015. And I think since 2015, many bridges were already built, but there are still many bridges to build, because there are still a lot of gaps. So, but after this short intervention, I just want to give you my closing remarks. You know, I was not able to follow the whole conference, only the last hour, and this hour was really very, very interesting. Professor Forgo asked me in advance to speak a little bit about anonymization and pseudonymization, and I have, yes, I've prepared some things, but no slides, so it's easier to follow, so you have to listen. I think we are aware that to non-experts, the differentiation is confusing, and that often data is called anonymous while it is indeed merely pseudonymized. Particularly in the context of contact tracing apps, this was visible, and we heard about that. And it was written in many newspapers and in many articles, and there was always the mixing up. It is important to underline that the GDPR does not make reference to pseudonymized data, but to pseudonymization. Pseudonymization, you know, is a process of transformation of personal data in a way that they can no longer be identified without the use of separate information kept separately. This is also how it is defined in ISO standard, the replacement of an information by an alias. A good example of pseudonymization is the key coded data in the environment of health research. The names of the individuals are known, but replaced by numbers. The key is held by the practitioners, and individual names are not shared to the researchers. As this process improved the level of protection and protect the data, it was recognized as a security measure. Another example of pseudonymization is encryption, and the European Data Protection Board, Professor Vogel, just introduced me as the chair of the European Data Protection Board, which took effect in May 2018 with the entry into application of the GDPR. The EDPB clarified repeatedly that encryption does not generally make data anonymous, but rather pseudonymous. Data, having been pseudonymized, remains personal, as you all know. Because if a controller processes digital unique identifiers to identify individuals instead of their family name, this has to be considered as a personal data. There is not pseudonymization here because there is no action to replace personal data with an alias. There is no reduction of risk or improvement of security. I'd like to make a differentiation between personal and non-personal data. From now on, I believe that the differentiation between personal data and non-personal data is still meaningful. This is also the reality from a regulatory point of view. We have the GDPR for personal data and Regulation 2018-1807 on free flow for non-personal data. Of course, the test of considering a data being personal is built on an objective risk-based approach. One should look at all the means reasonably likely to be used by anyone to identify the individual, meaning to be able to single him or her out. Of course, due to the improvement of the technologies, we are aware that it is becoming more and more difficult to be able to ascertain that data is indeed anonymized. The GDPR follows in many parts a risk-based approach. Recital 26 could be read as this risk-based approach to be applied on the question of anonymization. If there is a question, if there is a dispute between absolute and relative personal data, and what does it say? I can only say that until now, the EDPB doesn't have a concrete position on this, but it feeds, of course, into the next question. The next question is raised regarding recital 26 of the GDPR. This recital stipulates that to determine whether a natural person is identifiable, account should be taken of all the means reasonably likely to be used, such as singling out, either by the controller or by another person, to identify the natural person directly or indirectly. To ascertain whether means are reasonably likely to be used to identify the natural person, account should be taken of all objective factors, such as the costs of and the amount of time required for identification, taking into consideration the available technology at the time of the processing and technological developments. It is important to note that it is not sufficient to just consider one's own means available to re-identify a data subject. You need to consider that someone with stronger means or with a strong motivation to access the data might be able to re-identify a person even if you yourself cannot. We have examples from the past where this went wrong, and I'm sure you know this. Available technology and technological developments are a moving target, both in terms of anonymization techniques as well as de-anonymization attacks. And so the question was also raised to me. I was asked if the Working Party 29 documents, Working Paper 6, anonymity, on the internet and working paper 2016 on anonymization techniques are still relevant. As I mentioned before, the issue of anonymization is a moving target because of technological developments. Anonymization needs to be sufficiently robust. We have new technologies appearing, and while the GDPR is technologically neutral, the specific applications will have to consider concrete techniques. The fundamental issues, however, are still relevant. We realize that this is an important and difficult topic, particularly when the data is supposed to remain useful after anonymization. The European Data Protection Board recently made an important point by declaring that anonymization of personal data is an alternative to deletion, provided that all the relevant contextual elements are taken into account and the likelihood and severity of the risk, including the risk of re-identification, are regularly assessed. The Article 25 of the guidelines on data protection by design and default, paragraph 53 and 54 are the relevant ones. And we adopted these guidelines, and you are one of the first who will hear this. Though you have read our press release, these guidelines were adopted on last plenary on October 20th. So I think you are quite on top of the edge regarding information. And I think this is very fine to know, and it will be on the website of the board, I think, within the next days. The last question I was asked by Professor Forgo was the meaning of paragraph 18 of guidelines 04/2020. It's really very technical issue. The paragraph in the guidelines on the use of location data and contact tracing tools in the context of the COVID-19 outbreak says that many options for effective anonymization exist, but with a caveat. Data cannot be anonymized on their own, meaning that only data sets as a whole may or may not be made anonymous. In this sense, any intervention on a single data pattern by means of encryption or any other mathematical transformation can at best be considered a pseudonymization. This refers to the previous explanation. Anonymization does not take place in a vacuum. A substantial context needs to be considered for anonymization. It is a question of robustness. Moreover, we also clarify that pseudonymization is different than anonymization. And now I'm already at the end of what I've prepared regarding the question of Professor Forgo. And I think it helps us quite a lot that the GDPR is technologically neutral, also for the future development of technologies, because you can use it also and put it over AI, and you will never fail if you do it in the correct way. Thanks for your attention, and thanks for inviting me to make the closing remarks to your really interesting conference today. Thank you so much.
Thank you. Thank you so much, Dr. Jelinek. Thank you so much, Catherine, to you for organizing all this so brilliantly. Thank you to all our panelists and speakers. And last but not least, thank you to our audience who stayed with us for the whole day now, although it's rather exhausting to follow a video presentation for the whole day. I will not close this. This is the task of Catherine to do this. So kindly be so kind to close the session, Catherine, please.
So thank you again to all the attendees and all the speakers. I'm very happy to have organized this first, let's say, online event, and we hope to see you all also in IDLaw 2021. And yeah, thank you again.
Stay with us. Thank you.